Welcome back. This is The Firm. Dishonouring a cheque is an offence, and some 40 lakh pending cases in India are bounced cheque cases. The problem promised to worsen after the Supreme Court last year said if a cheque bounces, the case can only be tried in a court where the drawee bank is located. Now, that meant if Mr. X in Chandigarh makes a cheque payment to Mr. Y in Mumbai and the cheque bounces, then Mr. Y must go to Chandigarh to file the case against Mr. X. Recognizing the difficulties this caused, the government attempted to amend the Negotiable Instruments Act 1881 and clarify the jurisdiction issue. But Rajya Sabha was adjourned before the bill could be passed. So now an ordinance has been promulgated. Does it fix the problem or create new ones? To answer that question, I have with me Pramod Rao, General Counsel, Citi India, and well-known criminal lawyer Aman Lekhi. Gentlemen, to both of you, thank you very much for joining us and a warm welcome. Mr. Lekhi, I know when we previously spoke to you on this matter, that was late last year when the Dashrath Rathod case order was out by the Supreme Court, you had said in your response that the Bhaskaran case decision by the Supreme Court in 1999 left the field too wide open, and that there needed to be a narrowing of the field, but maybe the Dashrath Rathod case order was not quite the solution. Can you talk us through the history of this situation?
Yes, absolutely. The occasion for Rathod was the confusion created by Bhaskaran. The reason for confusion by Bhaskaran was the way the judgment actually set out how a cause of action for bouncing by cheque would actually evolve, giving as many as about 5 instances which were required to be satisfied for the purpose of initiation of proceedings. That gave an option to the person to whom the cheque had been issued to actually file a complaint in different jurisdictions, which could amount to harassment of the person who had actually issued the cheque. Now, it was this which actually moved the Supreme Court in Rathod to actually intervene for the purposes of undoing what it perceived to be a wrong enunciation of law in Bhaskaran. Now, what the Supreme Court did in Rathod, however, while addressing the problem of Bhaskaran, was to create another problem, because while it correctly identified that Bhaskaran required the problem and Bhaskaran required to be remedied, the solution which it provided was also not correct legally. Now, I say the solution was not correct legally. There were basically 3 reasons. One, insofar as the Supreme Court was concerned, the Supreme Court referred to the judgment in Ishwara Loy's case, which in my opinion was not relevant at all. 2, the Supreme Court ignored 179 of the CRPC, which is relevant for the issue. And 3, what the Supreme Court did not actually consider was that insofar as the issuance of cheque is concerned, the way in which it interpreted the proviso to Section 138 was completely incorrect. Now, while it is absolutely imperative that there should be no confusion insofar as jurisdiction is concerned, the jurisdiction would be necessarily governed by the provision of the CRPC, which is actually the operating statute for the purpose of deciding where a complaint is to be filed. Now, the way in which 138 is now drafted, it is not simply the dishonour, but the consequence of dishonour. The consequence of dishonour evidenced by the issuance of notice and failure to pay, which completes the cause of action. And because the consequence of dishonour is virtually part of the defence, because the dishonour by itself would not necessarily lead to a prosecution, the factum of the dishonour and the consequences would necessarily arise where the payee is situate. So keeping that in mind, the appropriate forum, while if the Supreme Court was right, could not be 5 different ones as was said in Bhaskaran, the appropriate forum should have been where the payee actually presented that particular cheque, not necessarily the drawee bank, which the Supreme Court had actually said in Rathod's case. So while finding out the problem, the solution which the Supreme Court gave actually compounded it.
Okay, fair enough. Mr. Rao, would it be fair to say that from an institutional point of view, the difficulties caused by Rathod are almost insurmountable, and therefore an amendment or even an ordinance to that extent was urgently required?
I would think so. I think indeed from the perspective of what Rathod had created was clearly going to hurt the people who were recipients of the cheques, and indeed it needed to be rectified. And that's what the ordinance is seeking to do. While I agree that it's departed from what the bill had, and undoubtedly it is because of the feedback both from the industry as well as the corporates who rely on such cheque payments, that the government probably mooted a changeover from the bill to the ordinance.
Okay, I just want to spell out for our viewers what the amendment bill intended to do and what the ordinance has ended up doing. So the amendment bill, which in fact was approved by Lok Sabha but couldn't make it through Rajya Sabha, said that that court will try the case within whose local jurisdiction the bank branch of the payee, or where the payee presents the cheque for payment, is situated. Now, this is exactly what Mr. Lekhi had suggested as the ideal solution in his previous response. But the ordinance does not stick to what the amendment bill suggests. It in fact says that the case can be filed in a court within whose local jurisdiction the bank branch where payee maintains the account is situated, or the branch of the drawee bank where the drawer maintains the account is situated. Would you say, Mr. Rao, that this departure from the amendment that the ordinance makes is in fact reverting us to the same position as Rathod left us in?
No, this is now given two options. One is to actually approach where the drawee bank is located, or where the person who's recipient of the cheque is based. So to my mind, it is departure, but it's not really going back to Bhaskaran in that sense.
There are two things I want to mention over here. One is on principle and the other is so far the ordinance.
Okay.
Now the ordinance is basically temporary law. The temporary law because the parliament is not in session and urgency requires intervention. Now if that is so, in that event the executive, while making the ordinance, cannot disregard what the legislature has actually done. In this particular case, admittedly there was a bill. Now the bill actually referred only to one single instance. Now that bill could not be passed because the Rajya Sabha could not consider it. Because the Rajya Sabha did not consider it, but the bill was there, the ordinance should not and ought not to have departed from the bill. So for the ordinance to actually make a change, though of course it's not very significant, as I will explain presently, was not, in my opinion, appropriate constitutionally. And so far as the principle of good governance is concerned, I personally think this is inappropriate. That said, insofar as the ordinance is concerned, to the extent it deals with the second clause, in fact, what the operative part is that unless the cheque is presented through an account. Now, unless the cheque is presented through an account, in that event only it will be the drawee bank. That means if you across the counter, I presume if the cheque is presented, in that event it will be the drawee bank, because as far as the pay is concerned, the pay will be actually going to the drawee's bank for the purposes of encashing the cheque. In that event alone, it will be the drawee bank which will actually be relevant for the purpose of jurisdiction. But the law would be basically what was in the bill, that insofar as the jurisdiction for the cheque which has been presented through an account, the appropriate forum would necessarily be where the payee bank is situated, which is in fact the correct position considering the requirement of law, the object of the act and the convenience of the complainant.
So I get the point you're making, Mr. Lekhi, that while the departure in itself does not inconvenience the solution, the process is questionable. And I want to add there the fear that, after Rathod, a bunch of cases were sought to be transferred based on what Rathod directed. Now we had an amendment bill and then we have an ordinance. If cases are transferred as per the ordinance back to, let's say, the jurisdiction, let's say, where the payee's bank account resides or is situated, and for some reason, God forbid, the ordinance lapses and the act or the bill is not able to make through Parliament for whatever reason, we could have judicial confusion. Or am I exaggerating the problem?
Quite so, Menaka. I think, I would actually go on to elaborate and say that it's not as if the ordinance is fully solving the problems on the ground.
Okay.
So apart from all of the transfer and retransfer of cases that both Rathod and now the ordinance will sort of propel, I think there are two aspects which the law has sort of not focused on.
Okay.
One is that indeed in today's era we operate on a check truncated system, the CTS system. And what it entails is that it's only images of check that travel and not really the check itself.
Right.
And secondly, it is coupled with what is the cash management services provided by banks to corporates. So really, whether through correspondent bank, their own branches, or pickup locations which might not even be bank branches. So we are talking about where the current reality on the ground is not what the ordinance or the amendment bill really factored in. I'm just hoping that this actually propels a debate around what's really required and what is not. And to me, ignoring both the CTS system, its prevalence, as well as, the fact of CMS, check pickup, etc., which happens as a corporate service by banks, they all need to be factored in and then measured whether the statute or the ordinance has fully addressed that or not.
So what are your recommendations on that front?
Can I just come for a minute?
So,
Yeah, sure. Mr. Rao, just 1 second. We'll let Mr. Lekhi.
Yeah, just so that Mr. Rao can deal with that also. The point is well taken. In fact, unfortunately, we don't have a law like the Netting and Settlement Act, which is there in other jurisdictions. But that would not require amendment to the Negotiable Instruments Act as such. This particular issue, insofar as 138 is concerned, that will require a holistic and a very comprehensive review, which the RBI itself is recommending, which will require a different statute, different content altogether.
I think the centricity of what the ordinance is doing is putting the jurisdiction basis the location of a bank branch. I think really if it focused on where the person who received the check was, or really where the person who issued the check was, that would have been a better basis. And that would have made it opaque to whether we are using check truncation system or whether we are, doing just images which are being transmitted. For instance, we have various banks in the country which might have a single branch, but are offering CMS services across the country. It will force corporates who are probably outside of that branch's location to actually have to come to that branch or where the jurisdiction of the court of that branch is. So to me, technically it's actually not solving the problem, or may indeed cause issues for those who avail of all of the, as I said, the collection system or check pickup system and so on. So that's where one of the difficulty lies. And to me, as I said, I'm hoping that the bill and the ordinance and the debate which will ensue will hopefully address all of these practical realities. To Mr. Lekhi's point, there is a Payment and Settlement Systems Act, there is a contemplation of netting and so on. I'm not saying that the check system needs to migrate into that culture. I think that is quite independent and indeed works quite well. It is, however, the issue of checks itself which has created from 1988 onwards this criminalization of check bounce, and which is where I think we've been plagued with whether Bhaskaran or now Rathod and now the ordinance, not recognizing the technology and the service developments that have occurred in the sector.
That's a fair point, Mr. Lekhi. In fact, I wanted to list that as one of the questions in my discussion as well, saying that, it is an 1881 Act, and I do understand that it has been updated over time, but really, is it equipped to deal with the modern financial economy?
No, absolutely. See, the Penal Code is of 1861, the Civil Code is 1908, the statutes are old, merely because the statutes are old doesn't necessarily mean that they can't apply to contemporary situations. No.
So I'm not, Mr. Lekhi, at all suggesting that because it's an old act, it should be junked or redone. I'm just saying, in the day and age of mobile money, do we need to redo this act from scratch?
What Mr. Rao is saying does require consideration. In fact, these are things which should necessarily be spelled out, and ideally any act should actually deal with it, and deal with it with specificity, because they are dealing with criminal prosecution, they are dealing with liabilities, they are dealing with imprisonment, dealing with penalties. Okay, fair enough.
Mr. Rao, I'll give you the last word, because I know that you work in an industry that is plagued by this on an hourly or minute-by-minute basis. I understand that the ordinance needs to fix urgently what it needs to fix, which is the situation emergent from the Rathod decision. But besides that, the recommendations that you've made, what would you prescribe in terms of the process that the government should go about in rethinking this act altogether?
See, so I will make 2 or 3 points if time permits. So one is that, for instance, if you see in the ordinance, there's a definition introduced of e-check.
Right.
Frankly, that's not even in contemplation in the current market situation. We do have, as I said, check imaging through check truncation system that is used, but nobody digitally signs a check. Digital signatures have not taken off at all, and nor do we as banks propose introducing checks on those formats. To me, again, it's a misconception at some level by the drafters who've sort of thought that we are bringing in something which addresses what is the current environment. But I would go much more deeper than that. I think you mentioned at the start of the conversation that we have as many as 40 lakh cases pending under this particular provision. I would actually say that of course, while you remarked about how old the legislation is, the criminalization is as recent as 1988. It's at that time that 138 got introduced and the check bounce got criminalized. It was in an environment where people had lost confidence in the checks that they received, and it was to restore that confidence with the criminality that the Parliament came back on that issue. I think, again, there have been several developments in the financial service sector. The primary one of them is actually emergence of credit information companies or credit information bureaus, really. So 10 years back, we had the Credit Information Companies Act, which was enacted. There are at least 4 or so bureaus which operate in this domain. To me, it's the right time to consider repeal of 138 to actually say that we will declog the justice system. We will drop or abate the 40 lakh odd cases and decongest the judiciary. The alternative is that all of the check bounces can start getting reported into the credit information bureaus, and credit histories will start reflecting people whose checks have bounced, and people who are dealing with them can rely on the credit report to make their determination. Do they want to deal with them? Do they want to demand pay orders or demand drafts? Or do they want to, sort of say, okay, I'm willing to take the risk of a check after all. But I think it's the right time to initiate the debate on saying decriminalization is probably necessary. It is a provision that has probably outlived its existence. And I say this from both the progress of the cases that we are seeing 40-odd lakh cases. We are seeing in 2010, Supreme Court introduced a compounding scheme. So when a person thinks a conviction is being reached, he can actually just get the case compounded. It defeats the entire object of wanting to prosecute somebody, though clearly realization is affected. There have been many courts which have remarked and said, you've made us into recovery agents for people who are the payees of these checks. To me, all of these are mindsets. We need to move away, as I said, from criminalization. We need to decongest the judiciary. And we have a modicum of check and balance, which to my mind is the credit report.
With all due respect to Mr. Rao, I completely disagree with him. Insofar as the decriminalization is concerned, I'm not in agreement at all. He mentioned 2 or 3 points I'll deal with. First of all, as far as compounding is concerned, compounding is always part of the legal system. Now, the compounding, implicit in compounding is acknowledgement for wrong. Only question which compounding is doesn't cause imprisonment. The purpose of the Negotiable Instruments Act is not to punish to imprison. The purpose is basically to enhance credibility of a check. Enhance credibility of the check so that to ensure that person who draws the check actually makes payment in terms of the check, which is actually being enforced. Number 2, the courts cannot say that they are becoming recovery agents, because as far as the manner in which the statute is drafted, the purpose is to enhance the credibility of a check, and insofar as the drawer of the check is concerned, once brought to court, if he is obligated to pay, which is in fact the mandate of law and the initial obligation itself, the courts cannot possibly say the recovery agent, because the courts are basically enforcing the law as it avails. Number 3, insofar as the credit agencies are concerned, this is, insofar as a theoretical basis, it may seem very attractive, but it's got very little practical utility, because the person who has, I'm talking about individual check holders who want checks, in fact, who would be carrying checks to basically not worth the paper they are written on, would actually be wanting money. And insofar as the money is concerned, whatever the procedure or process is there, the process is actually availed for the purposes of ensuring that the payment is actually received by them. So while we have to consider other aspects, we have to deal with the law to make it more specific for the contemporary situations. Considering the existing reality, I personally feel that there is no occasion nor need for decriminalization of 138.
All right, gentlemen, I'm very tempted to continue this further, but in the interest of time and because we're at the end of the show, I do have to close this debate here. But thank you to both of you for your time and for your insights, for clarifying the ordinance, and for also suggesting or starting the debate on what the future of 138 ought to be. Pramod Rao, Aman Lekhi, thank you for joining us on this edition of The Firm, and thank you very much for watching. We'll see you next week.
The Firm, India's only show on corporate law, tax and audit matters.